Chapter 7. Indemnity on Lost Instruments, Sec. 134. Scope. It sometimes happens that when a bond, note, certificate of deposit, certificate of stock, insurance policy or other similar obligation for the payment of money, becomes due, the person to whom it was issued claims that it has been lost, stolen or destroyed, and therefore that he cannot produce it. If the maker of the instrument should under the circumstances pay it, he would run a twofold risk. In the first place, the instrument may not really have been lost, stolen or destroyed, as alleged, but may have been sold or assigned to a third person. In the second place, if it has been lost or stolen, and not actually destroyed, it may get into the hands of a person who will be entitled to it as against the true owner, who lost it. Accordingly, the maker of the instrument, as a condition precedent to paying it, or issuing a duplicate, may require that a bond be given to indemnify him against loss in consequence of so doing. Surety companies are frequently asked to issue such bonds, and they form one of the more important of the minor classes of surety bonds. Sec. 135. Liability. The maker of the instrument generally requires such a bond as will obligate the principal and surety not only to reimburse him in event he is required to pay the obligation a second time, but also to pay all incidental costs, expenses and counsel fees. Indeed, in many cases, the principal purpose of the bond is to guard against possible expense, and in view of the well-known fact that people do make claims and bring suits that have no merit in law, it is apparent that a loss may be sustained, notwithstanding the instrument may be of such a nature that, under the circumstances, a third person could have no legal title to it as against the principal. Sec. 136. The risk. In general, the desirability of such a risk is of course largely affected by the financial strength of the principal, for it is true in this case, as in all other cases of suretyship, that the principal stands between the surety and loss. But the object of this work is to point out the risk peculiar to the different bonds, it being the prerogative of each underwriter to say how much financial strength an applicant ought to have to justify a surety company in taking that risk. The risk under these bonds will therefore be considered from the standpoint of the personality of the applicant, insofar as it may affect the question of his veracity, and the nature and condition of the lost instrument, insofar as it may affect the probability that it will find its way into the hands of a person who will be entitled to recover on it, notwithstanding the issuance of the duplicate, or the payment of the money, to the principal. Sec. 137. Risk, as affected by the personality of the applicant. As will be more fully explained in the succeeding paragraphs, a surety underwriter, in passing on an application for a bond of this kind, ought to know, first, that the instrument has in fact been lost, stolen or destroyed, and not assigned or transferred to a third person, and, second, he ought to know the nature and character of the instrument and the circumstances under which it disappeared. In many cases, the only way of getting any information as to these material facts is through the applicant. His affidavit ought to be required in all cases, and it is important to make such an investigation of his character and standing as will be sufficient to show that reliance can be placed on his word. It is hardly necessary to add that the statements of the applicant ought to be verified as far as may be possible. Sec. 138. Risk, as affected by the probable destruction of the instrument. If the instrument has in fact been destroyed, as for example, by fire, and not merely lost, mislaid or stolen, and if, at the time of its destruction, it belonged to the applicant, there is of course practically no risk on the bond. While it is hardly possible to become absolutely sure of the destruction of the instrument and the title of the applicant, yet if the applicant is a person of good standing and reputation, and makes affidavit to facts which show, to a practical certainty, the destruction of the instrument, and further makes oath that he was the owner of the instrument and that he had not endorsed, transferred or assigned it, it is perhaps reasonably safe to assume that what he says is true. However, each case will have to be governed by its own particular circumstances, for it cannot be said in advance what evidence of ownership and destruction ought to be accepted. The point to be emphasized is the distinction between a case where the evidence shows to a practical certainty that the original instrument is not in existence, and a case where the instrument is merely lost, mislaid or stolen, and may be in the hands of one who can recover on it or who may have reasonable grounds to believe and contend that he can recover. In the first case, the bond may be executed almost regardless of the financial standing of the principal, so long as his moral standing is good enough to justify a belief that his statements and affidavit are true. In the second case, it ought to be assumed that the instrument is in the hands of a third person, and the desirability of the risk should be tested by the question whether or not such third person could probably recover on it. This question will next be considered. Sec. 139. Risk, as affected by the character of the instrument. The question whether or not the holder of an instrument that has been lost or stolen can recover on it is a difficult legal question which is beyond the scope of this work, but it is possible to point out certain principles which have an important bearing on the risk of the surety. In the first place, it may be said to be a general rule of law that in order for one to become a bona fide holder for value of a lost instrument, or a holder in due course, as he is sometimes called, so as to entitle him to recover as against the true owner, he must, among other things, have purchased the instrument before maturity. If therefore, the particular instrument was lost after maturity, or if, though lost before maturity, a considerable time has elapsed since maturity and no demand has been made, it may be fair to assume that no demand will be made, or if made, that it will not prevail. In the second place, in order for the holder to be considered a holder in due course, he must not only have paid value for the instrument, but he must have received it in good faith, without knowledge, express or implied, that it was lost or stolen. It is needless to say therefore that the finder or thief could not recover as against the true owner, nor could one who was actually or impliedly in collusion with the finder or thief recover. The instrument must have been transferred to an innocent third person for value. The risk therefore will be affected largely by the ease or difficulty with which the instrument could probably be thus transferred. In considering this question, it will be convenient to divide the instruments into three classes. First, we have those instruments which are transferable by mere delivery without any endorsement, such as mortgage bonds and notes, certificates of deposit, etc., payable to bearer, or instruments which, though payable to the order of a particular person, have been endorsed by him in blank. If such an instrument were offered for sale, the suspicions of a prospective purchaser would ordinarily not be aroused and a sale could probably be made. This is the most dangerous class, and, unless such an instrument has undoubtedly been destroyed, or has long since matured, it is not a legitimate surety risk. In the second class, we have those instruments which, though transferable by endorsement, have not been endorsed by the payee, and where, in order to negotiate them, the signature of the payee would have to be forged. Under the Uniform Negotiable Instruments Law, which is in force in many of the states, a forged signature is wholly inoperative to pass title to a negotiable instrument, and no right to enforce payment against any party thereto can be acquired through or under such signature. If that is the law in the particular state with respect to the particular instrument, and that instrument has not been endorsed by the true owner, then it is practically certain that no third person can acquire a title that will be good as against the true owner. The third case is that where the instrument is not, strictly speaking, a negotiable instrument, in the sense that it may be transferred by endorsement or mere delivery, but where an assignment is necessary, as for example, an insurance policy. It is hardly possible, under any circumstances, to pass title to such an instrument by a forged assignment. And if the instrument has not been assigned, there is practically no chance that a claim could successfully be made by a third person. The contingency that insurance companies really intend to guard against is the possibility that the insured may in fact have assigned the policy. Reference has already been made to the importance of ascertaining the genuineness of the loss. Sec. 140. Summary. The substance of this chapter may be summarized as follows. 1. Where the instrument actually has been destroyed, and was, at the time of its destruction, the property of the applicant, there is little, if any, danger of loss. 2. Where the instrument is transferable by mere delivery, and is not known to have been destroyed, the risk is hazardous, until a considerable time has elapsed after maturity. 3. Where the instrument is transferable only by endorsement, and has not been endorsed, there is generally not much danger. particularly if the instrument has matured. But where the negotiable instrument law is not effective, the law as to the effect of a forged signature may be different. 4. Where the instrument is not negotiable, but is transferable only by assignment and has not been assigned, there is little chance of loss in any state. The foregoing propositions depend upon the accuracy of information which can often be obtained only from the applicant, hence the importance of investigating his character and standing.